contracts. And the third is obligation of a person who has enjoyed the benefits out of a non-gratuitous act. There is an obligation on the person who have enjoyed the benefits out of a non-gratuitous act. That I'll just give an illustration. Suppose a person who is running a grocery shop, he has just kept some vegetables and some fruits outside the shop. Actually, it's kept for sale. I have just used it. So it is the duty that I have to pay the amount. Because that is a non-gratuitous act, that is for consideration. These properties are kept for sale. So there is a consideration. Another example, if someone has come to my home and they came for delivery of some articles. But the thing is, they have mistakenly left some pair of chappals. Actually, that was kept for sale. And I've used it. It's a quasi contract. I have to pay the amount. Even though that was kept mistakenly, that was just delivered, or that was just kept, or that was actually they have just taken that property for sale, then it is the duty that of me or myself that I have to pay the amount. So that is the obligation of a person enjoying the benefits non-gratuitously, because that particular act should be for a consideration. That was not just that they were all brought or kept for sale. And the fourth instance, or the fourth mode of quasi-contract, that is finder of lost goods, as dealt in section 71. Very important section. As I've already mentioned, while I'm just walking, I've just got a gold coin. This is the last one. So what I have to do is I have to take care of that good, as if an ordinary prudent man would take care. I should just find out the real owner. I should give back that property. So I should keep the property as if I'm a baby. Or suppose I have just received some goods which are of perishable nature. At that time, I can sell the property, and the proceeds of the sale I can just give to the real owner. So finder of lost goods, with respect to that particular aspect, that is a quasi-contract. So I should actually keep that goods as if a prudent man would take care. As if an ordinary man of prudence would take care of that property. And then I should give back it to the original owner. Suppose that is of perishable nature, I can sell it, and the proceeds of the sale can be given to the original owner. And the last point with regard to the quasi-contract, fifth mode is, if I am paying some amount and that is given mistakenly to another person, or the amount is paid out of a coercion, then you can say that that particular amount has to be given to the right person. That is a quasi-contract. That I just can give you example. If you are paying the amount through Google Pay, or you might have mistakenly paid to another person. So the person who received the amount has to be restored, reimbursed to the exact owner or exact person for whom that amount has to be received. So if an amount is paid wrongfully or by mistakenly, or you could say that by coercion, if you are getting that amount wrongfully, it has to be restituted. It has to be reimbursed to the person who should have received that amount. So these are the 5 modes of quasi contract. That is, 1, as we all know, when the necessaries are supplied to a person who is incapable of entering into contracts. Second is payment by an interested person. Third is there is an obligation on the person who has enjoyed the benefits out of a non-gratuitous act. And fourth point, finder of lost goods. And the last is payment by mistake or coercion. In all these cases, this is a quasi contract or constructive contract or pseudo contract. A person have enraged unjustly, that the person sustained wrongful loss. The person who have benefited has to restitute or reimburse the amount to the person who have sustained the wrongful loss. What are the advantages of this? Advantages, you can say that the wrongful loss person or the person who has sustained the wrongful loss has a remedy. He can sue when it is not restituted or reimbursed. And it is more flexible, and it's also giving a protection to the person who has sustained wrongful loss. And what are the disadvantages? Of course, there is a dispute between the parties. Then that is not a formal contract, but there is some sort of uncertainty or ambiguity. And again, you could say that the remedies are not at all adequate. So these are some of the disadvantages you could see with respect to this quasi contract. So this is a subject, and if there is any doubt, you can ask. Okay. It's over. Quasi contract is.